Again, I would like a chance to welcome all of you. For those of you who do not know, am Linda Chavez. I'm president of the Center for Equal Opportunity, and the Center is a conservative organization that deals almost exclusively with the issues of race, ethnicity, language, and assimilation. At least we are described as conservative and by some of the people in this room. And I must say that if you had told me a couple of years ago when I started this organization that as the president of CEO, I would one day be hosting a luncheon to honor a liberal from Massachusetts named Kennedy, I would have told you you were crazy. But in fact, that is what we are here to do today. And it is in fact a great honor to be able to host Professor Randall Kennedy from Harvard University. Those of you in the room obviously know that Professor Kennedy is a professor at Harvard, and he earned his undergraduate degree at Princeton and his law degree at Yale. Professor Kennedy has taken on what is surely one of the most volatile public policy issues in America today, and that is the issue of race and crime. And to do so, and particularly to do so with the kind of integrity manifest in this book, requires an enormous amount of courage. The intertwining of race and crime is complicated. It's fraught with the baggage of our history as a nation. It is impossible to ignore that history when we talk about the subject of race and crime. And Professor Kennedy's book, in a very important way, challenges different people in different ways, and particularly different camps in the debate about race in America, namely the liberal camp and the conservative camp, in very different ways. He challenges liberals to confront the fact that, as he puts it, the principal injury suffered by African Americans in relation to criminal matters is not over-enforcement of the laws, but under-enforcement. I think anyone living in Washington, D.C. can clearly recognize that the levels of criminality that those who must live in Northeast Washington or Southeast in what are primarily African American communities, those levels of criminality would never be tolerated in the white neighborhoods of this city and its suburbs, or indeed any major city in America. But he also challenges conservatives, particularly those of us who have spent our professional lifetimes arguing for colorblind policies. We want colorblind admissions to universities, we want colorblind hiring, we want colorblind promotion. But are we prepared to deal with the kinds of colorblind law enforcement that Professor Kennedy writes about? Are we prepared to prevent the police from, as Professor Kennedy puts it, using race as a proxy for dangerousness? I thought a lot about this issue, knowing that I was going to be sponsoring this luncheon for Professor Kennedy. And I must say, as I was thinking back on my own experiences and the one time in my life when I became an almost victim of a serious crime, I was forced to think about some of the issues that Professor Kennedy raised. Some 20 years ago, I was living in upper northwest Washington in a neighborhood called Shepherd Park, and I had just given birth to my second son, Pablo. And I was home with him and nursing him and put him down to bed in his bassinet in my living room and was headed to the kitchen for a cup of coffee when I realized, as I walked through the living room, that there was a man hidden in the corner underneath my stairway that went to the second floor. And in one of those moments which I look back on with utter amazement and think that it must have been providential, it must have been miraculous, I reacted in precisely the right way. I didn't flinch, I didn't in any way indicate that I saw this person, but instead continued walking into the kitchen, picked up the telephone, and called 911 to alert the police that a man had broken into my house and that I was there alone with my infant son. I then turned around and went back to face the man who by this time had moved into the center of the room. He was a young man in his early 20s. He was black. He was very well dressed. and when I told him that I had just called the police, he reacted with utter contempt, suggesting that I had somehow made some terrible mistake and that he was simply there to inquire whether or not I needed my hedges trimmed, despite the fact that it was in the middle of the month of January and there was snow on the ground. He then acted quite insulted and turned around and walked out the door, and the minute his feet hit the pavement, began to run. Within 2 or 3 minutes, Washington's finest showed up at my door with their guns brandishing and pointed directly at me, and I informed them that, in fact, the young man had disappeared. I gave a very careful description. My husband's 6'2". This man was at least 2 inches taller. He was about 6'4". He was very distinctively dressed. He had on dark blue pants, bell-bottoms, as it happened in the fashion of the time. He was wearing a camel hair coat, certainly not the kind of garb you would wear to trim hedges. And I estimated his age as late teens, early 20s. For the next hour or so, the police combed my neighborhood and brought prospective persons to my door for me to identify whether or not they were in fact the man who had broken into my house. After about the third black man had been brought to my house, I realized that the only thing that the police heard in my description, my very careful description, were the words black male. And in fact, because Shepherd Park, for those of you who know it, is a very well integrated neighborhood, in fact it's a majority black, it was then as well, most of the people that they were bringing to my door were in fact my neighbors. And in fact, the last man that was brought to my door was a man about 60 years of age, and he was wearing a work jacket and dungarees. And when I looked into his eyes and saw the anger and the humiliation that he felt as he looked at what he, I'm sure, perceived as this accusing white woman, I realized that even in this case, some of the police were black, that in the eyes of the police, the dangerousness, the part that they heard about my description, the fact that this man was an intruder into my home, the only thing that mattered was in fact his race. Well, I say that in introduction to Professor Kennedy's book because he has some very important things to say about such incidents as they happen throughout life. And I think he has some extremely intriguing notions about how colorblind law enforcement could ensure that those kinds of incidents never take place again. With that, I would like to introduce Professor Randall Kennedy, and he will speak for about 20-25 minutes, and then we will open it to question and answers. Thank you.
Thank you very much for that kind introduction. I'm very happy to be here and very grateful for this forum. I should say that this isn't the first time I've been at a forum at the center. On 2 previous occasions I came to the center to be part of various discussions having to do with race and the administration of criminal justice. And indeed, those 2 earlier occasions were very helpful in the writing of my book. Here I'd like to give a special note of appreciation to Linda Chavez. The fact of the matter is that I am a liberal. I'm a person who sits on the editorial board of Dissent magazine, The Nation magazine, The American Prospect. And the American Prospect, I guess, is probably the most conservative of the editorial boards that I'm associated with. We obviously have certain agreements, but also certain disagreements. And I have always been dealt with in the most cordial way, the most respectful way, when we're agreeing and when we are disagreeing. And I'm very pleased to be here, and I have been very appreciative of the way that you have dealt with me over the years. My book, Race, Crime, and the Law, is a book that deals with the history of racial controversies in this area, race in the administration of criminal justice. About a third of the book deals with the history of this area. In focusing on the history, one of my aims was to either introduce or perhaps to reacquaint people with some of the landmark decisions that have given rise to the constitutional law of criminal procedure. I mean, many of the rights that Americans now take for granted were shaped in judicial forums that involved racial controversies. For instance, the beginning of the constitutional right to an attorney when charged with a serious offense finds its origins in Powell versus Alabama, the first of the Scottsboro Boys cases. The constitutional right to a trial free of mob intimidation comes from Dempsey versus Moore. The right to be free from state torture, Brown versus Mississippi. All of these are cases that involved issues of racial conflict. In my sections regarding history or dealing with history, I spend a lot of time on the problem of racially motivated violence and the way that problem has shaped our statutes, our constitutional order, and the way that that problem has rankled in the consciousness of African Americans. So I spend a considerable amount of time in my book talking about the problem of lynching and how the legal order never responded adequately to the problem of lynching. After my historical sections, I deal mainly with contemporary problems. I have a chapter on police-citizenry interaction. I have several chapters on jury selection and racial issues. There's a chapter on race and prosecution, a chapter on race and the administration of the death penalty, a chapter on playing the race card in a criminal trial. And I'd be happy in question and answer to talk about any issue that would arise in those various categories. But for now, I think I'd like to pick up on an issue that was raised, or subject that was raised in Ms. Chavez's introduction, and that has to do with various camps. In writing this book, I wanted to talk to a broad audience. And by a broad audience, I wanted to talk to lawyers and judges, but I also wanted to talk to ordinary citizens. It seems to me that ordinary citizens should know about the laws under which they live, and so I tried to write a book that was accessible to all. I also wanted to write a book that would be directed at a wide variety of ideological camps. And I'd like to say a little something about these various camps. I wanted to write a book that would talk to people who view themselves as law and order enthusiasts. That is to say, people who in their politics view the imperative of apprehending criminals to be very important. I'm part of that camp. It seems to me that one of the essential duties of government is to protect the citizenry, and to protect the citizenry against crime. And so I'm a law and order enthusiast myself. Now, some people who talk about law and order, of course, use law and order merely as a code word, sometimes a code word which is meant to connote anti-black feeling. And I would suppose, frankly, that people who are of that sort are not interested in what I have to say, and I don't have high hopes of saying anything that would be persuasive to them anyway. On the other hand, I think there are a lot of Americans who are concerned about crime, who are afraid, who want the government to protect them, and I think that I can speak to that section of our population. And one of the things that I want to say to them is they have a right to be concerned. They have a right to demand protection from the government. And one of the things I want to tell them is that one of the impediments to efficient, effective, and decent law and order is the resentment felt in many parts of our society, especially among people of color, tremendous resentment felt against the guardians of law and order. It does not help law and order for African Americans and other people of color to feel resentment and distrust of the police. It does not help the efficient law and order for instance, young black law students to say that they don't want to be prosecutors because they don't want to work for the, quote, the man. It does not help anything for young blacks to say that they don't want to be police because being a police officer would involve being a traitor to their community. And one of the things that has to be understood is that nurturing these beliefs and these sentiments is a deep-seated cynicism towards the way in which the criminal justice system has acted towards people of color. And to drain that sense of resentment, we are all going to have to pull together and show very clearly, very vividly, that we believe in a legal system and are willing to enforce legal rules which treat all people equally, regardless of race, before the bar of justice. Let me go to another camp, the camp that marches under the banner of limited government, the camp that emphasizes that politicians have to be watched very closely, the people that say that indeed power corrupts and that we have to be very watchful of all government bureaucrats. They have a very good point. They have an excellent point. And one of the things that I want to say to them is generalize your argument. Prosecutors are government bureaucrats. Police officers are government bureaucrats. They too are officers of the state. I want to be supportive of them. They have very important roles, but they too can fall prey to corruption, including not just the corruption of being on the take, but including the corruption of invidious racial bias. People who are for limited government, people who want to make the government play by the rules have to insist that the guardians of law and order play by the rules. Therefore, if police officers are engaged in racial biased actions towards fellow citizens, all of us should make our voices heard and insist that government officials play by the rules. Let me go to another camp, the camp that marches under the banner of the colorblind Constitution. And here I'm really picking up on the point that Ms. Chavez mentioned in the introduction. There's been a lot of discussion lately, actually not just lately, there's been a lot of discussion, it's been a sort of a front page story over the last 2 years. People arguing that under American constitutional principles we should look very askance whenever racial distinctions are made. Even when the intention is good, we should look askance at racial distinctions being made, and we should not allow them except under the most extraordinary of circumstances. It seems to me that that's good thinking, that's good doctrine. And again, I say let's generalize it. In the administration of criminal justice, we have a system now which authorizes police to take race into account in making determinations of suspicion. So in the Southwest United States, If you are a person of apparent Mexican ancestry, you walk around with a question mark over your head, at least in the eyes of the United States Border Patrol. If you're a person of Mexican ancestry, you're treated differently than your colleague who is a white Anglo. Or, in fact, your colleague who is clearly an African American. You're treated differently, you get more scrutiny by the law enforcement officialdom. All over the United States, in every place in the United States, black Americans, particularly black American men, walk around with a question mark over their heads. They walk around with this question, they walk around with the question mark follows them in their cars, the question mark is with them when they get off of planes, it's with them always. They are viewed as being more likely to engage in certain sorts of criminality, and therefore the police scrutinize them more carefully, act towards them differently. Now here I want to make a distinction. I want to sort of make a comment about racial discrimination. Oftentimes when we talk about racial discrimination is viewed as something that is tantamount to bigotry. Sometimes it is. There's a good amount of racial discrimination that comes from just pure racial prejudice. People act differently towards others because they want to put down people on the basis of their race. And that's important and that's evil, and we should be against that. There is also racial discrimination that comes from strategic thinking. Some people call it rational racial discrimination. Other people call it statistical racial discrimination. The idea is that as an empirical matter, isn't it true that under certain circumstances, as a pure sociological generalization, isn't it true that African American young men are more engaged in certain sorts of criminal activity than other sectors of the population? And if that's true, doesn't it make sense for the police to treat people with that trait differently than others? Now, it seems to me we have to deal with that. And the fact of the matter is that some sorts of racial discrimination is strategic. It's not based in bigotry. It's based in strategy. It's based in people trying to effectively effectuate the enforcement of the law, which is one of the reasons why, in many cases, people of color who are police officers act very similarly to white people who are police officers. They are both engaged in sort of using race as a signal, as a proxy for an increased risk of criminality. They're not saying that every black person's a criminal. They're saying, though, that there is an increased likelihood. Now, even if that is true, we ought not to allow the police to take race into account. In other words, even if it is rational, even if there is an empirical basis for this racial distinction, we ought not to allow it. We ought not to allow it for the same reasons that we ought not to allow employers to prefer white prospects for employment, even though white people tend to live longer than black people. That's true. That is simply a fact. White people tend to live longer than black people. An employer might say, it's better for my company to hire people who are going to live longer. It's true that as a statistical generality, white people have more education than black people. That's true. It's also true that white people, as a statistical generality, have had fewer negative interactions with the administration of criminal justice. All those things are true. But we do not allow employers to use race as a proxy, even though these things are true. We demand that employers engaged in individualized assessment in order to change our society so that these things which are true now will not be true in the future. And it seems to me the same sort of thinking that prevails in other realms with respect to our anti-discrimination law ought to prevail in the arena of criminal justice. Now let me go to a fourth camp, and then I'd be very pleased to get your questions, your comments, and your objections as well. The fourth camp is the camp that views itself as being primarily concerned with advancing the fortunes of African Americans and other people of color. It's a very distinguished camp that has done a lot of good work. In dealing with this camp, I have one, I think, large criticism. And that criticism is a tendency within this camp, I think, to exaggerate claims of racial discrimination and racial prejudice. And let me give two examples. One is an example that probably has somewhat limited, it's of somewhat limited importance, but I think it is symptomatic. I think of the people who say things like, there was the case of Tawana Brawley a number of years ago. Tawana Brawley was a young black woman who, in New York, who claimed that she was the victim of racially motivated misconduct or rape. There was a lot of publicity given. There was a grand jury investigation based on a lot of evidence came to the conclusion that this simply was not true, that this was a hoax. There were some people who, in what I'm terming the fourth camp, who took the position that the facts really just didn't matter, that the way that this should be viewed is as some sort of metaphor, that this could have happened. Now, that simply will not do. Exaggerated claims of, or untrue claims of racial prejudice should be just called for what they are and should not be tolerated for a wide variety of reasons, one of which is that it cheapens the allegation of racial discrimination. If the claim of racial discrimination becomes nothing more than the playing of the race card, if it becomes nothing more than a rhetorical tactic, it will be regarded as nothing more than that. And we can already see that that is happening. And that does not do any good for people who want to advance the case for racial justice in the United States. Let me give another example that, frankly, I would suppose would be much more controversial, and again, I will be happy to take questions and comments and objections about it. During the past 2 years, there's been a lot of commentary about the crack powder distinction in the war on drugs. There have been innumerable op-ed and editorial pieces written in our papers, innumerable essays written, saying that the war on drugs is really a war against black people. And one of the examples given often is the crack powder distinction. Under the law, certainly under federal law in many states, people who traffic in crack cocaine face much harsher penalties than people who traffic in powder cocaine. The people who traffic in crack cocaine tend, to a large extent, to be people of color. People who traffic in powder cocaine, there's a much larger group of people who are white who traffic in powder cocaine. So this has led to the claim that this distinction under which the people who traffic in crack go to jail for longer terms is racially discriminatory. And people say, look at the effect. 80%, 90% of the people who go to these long prison terms for crack cocaine trafficking are black people. This disparity shows racial discrimination. Now, I find that argument unpersuasive. One of the things that I did in my book was to do a search for, in the congressional record, on crack cocaine. I wanted to know, when did crack cocaine become introduced to the Congress, and who introduced the idea of cracking down on crack to the Congress? what I found was that Charles Rangel introduced the idea of cracking down on crack. Major Owens was very insistent that the Congress do something about crack. Congressman Charles Rangel is the African-American representative from Harlem. Major Owens is an African-American representative from a predominantly black district in New York. They were saying to the Congress, listen, there's this new type of cocaine packaged in a way that makes it very accessible to poor people, my constituents, and not enough is being done about it. We need to crack down on crack. Now, they were not saying this in order to make war against the black population. They were saying this because they recognized crack cocaine to be a particularly pernicious form of cocaine that menaced their communities. Now, a number of representatives have changed their minds about the crack cocaine issue and now want to lessen the penalties. And maybe they're right. I'm not speaking in favor necessarily of the crack powder distinction, nor am I speaking necessarily in favor of the current war against drugs. I'm simply saying that there was a rationale for what was done. There is a rationale for distinguishing between crack cocaine and powder cocaine. It is an eminently reasonable rationale. The reasons for this are reasons that our elected officials should be able to take into account and to put on our law books. We might come to the conclusion that they are wrong. We might even come to the conclusion that what they are doing is profoundly wrong. We might even come to the conclusion that what they have done is stupid. All of those things, however, are different than coming to the conclusion that they are acting in a racist manner. And there is a difference between somebody being wrong and somebody being racist, and in my view, it's a difference that matters. Now, let me end with sort of the two main points that I want for readers of my book to take away from the book. First, there's a lot of work to be done. The fact of the matter is there is still racial discrimination of various sorts in the administration of criminal justice. We all ought to mobilize against it so that we can have efficient, good, decent law enforcement that will protect us. So we still have a problem on our hands, point one. Point two, and I really want to underline this because apocalyptic pronouncements are so in evidence in discussions about race relations now. I want to emphasize that we live in a country in which there has been considerable change. We live in a country that is susceptible to change. If one takes a look at the chapters in Gunnar Myrdal's An American Dilemma, published in 1944, and ask, well, what did Gunnar Myrdal talk about with respect to the administration of criminal justice? What did the country look like in the mid-1940s? What did the country look like with respect to the mid-1950s? What did the country look like in the 1960s? And what does the country look like today with respect to the way in which our rules, the rules on the books and the rules in action? The fact of the matter is there's been considerable change. Again, I want to emphasize that we have problems, important problems, very significant problems. But there has also been change. And we ought to recognize that change. We oughtn't be afraid. We oughtn't be embarrassed. To be thankful, quite frankly, that we live in a democracy in which people can band together intelligently to recognize difficulties, confront those difficulties, and change the way that people think and act for the better. Our country is still a flawed society, but it is a society that is a lot better than it used to be, and we should all be thankful for that. With those remarks, I would love to hear your questions, comments, reactions.
Could I just ask each of you, when you ask your questions, to identify yourself by name and affiliation for Professor Kennedy? Thanks.
Mr. Bullock.
Clint Bullock from the Institute for Justice. Randy, I really enjoyed your book, and I thought that your criticisms of conservatives were very, very well taken, although I enjoyed your criticisms of liberals more. But the one area that I wanted to quiz you about is your embrace of the Racial Justice Act, which would redress the disparity not in capital punishment for people based on the number of the percentage of homicides committed, but the disparity based on the race of the victim. And it seems to me that in that kind of situation where you would get rid of capital punishment where those disparities existed, given that there are individual protections, and presumably each person who does get capital punishment in that instance deserves that punishment, there are enough protections in place to ensure that that outcome is a just outcome. What the concern is that some people are not getting capital punishment who also deserve it. Isn't reducing the penalty in those kinds of situations really the worst possible way to deal with that problem?
Well, actually, I don't embrace that act, or it's not an act, I mean the proposal. What I say about capital punishment is that we do have a history, a long history of undoubted racial discrimination in the administration of capital punishment. That too has changed considerably. I think what I said in my book is that with respect to the opponents of the Racial Justice Act, there are criticisms to be made of the Racial Justice Act. One of the things, though, that one of the things that I criticized is the unwillingness of many of the opponents of the Racial Justice Act to recognize, one, that there has been this history, and to recognize that it is probably the case that racial discrimination may seep in to the administration of the death penalty. It's very hard to make any large-scale claims. It's a very complicated area. After all, if the claim is that the racial discrimination that's been shown is that the states, that people who kill whites are more likely to be sentenced to death than people who kill blacks, one response is to say, well, if that is so, then that suggests that the criminal justice system is not being harsh enough with those who are killing black people. And so let's level up. That has its own difficulties. I think this is a very difficult area. What I was saying, though, is that we have to be aware that there is racial discrimination, and in the death penalty area, above all areas, I think we have to demand a type of super hygiene. On the question of the death penalty, I drop a footnote in which I call myself a rather ambivalent abolitionist. I used to be, and here I'll just be autobiographical for a moment, I used to be a very strong abolitionist, a sort of complete, thoroughgoing abolitionist. I could not see how people could even debate the other side or take the other side. I am still largely an abolitionist. I understand why many people want to, why the overwhelming majority of Americans want to keep the death penalty. One of the things that made me understand that was my time with Justice Marshall. I mean, reading the death penalty cases week in and week out made me understand why some people felt that In some instances, nothing other than the death penalty is sufficient to show the society's complete abhorrence of some of the crimes that people commit. But to get to your point again more directly, I think that the death penalty is a very difficult issue. I think on all sides that there is a certain sort of tendentiousness, and that some of the people who rally around the death penalty are tendentious in their unwillingness to recognize that racial discrimination will likely seep into practically every aspect of American life. I'm not saying that racial discrimination is absolutely prevalent. I've already indicated that there's been a considerable amount of change, but we always have to be aware that racial discrimination is a specter. It's very possibly there, and therefore in calculating how we're going to act, we have to take that into account. Yes, sir.
I'm Michael Horowitz at the Hudson Institute. I want to ask whether your prescription against what you call rational discrimination doesn't really reflect a utopian and a counterproductive view of what the law can do. Let me put it this way. Suppose you were a cab driver in D.C., and it was me and a black teenage kid calling for the cab. You'd be quite imprudent, I think. You could take it to stronger terms not to pick me up instead of the other kid. Now, I don't doubt that that kid might be the son of a Supreme Court justice. You'd get nailed, and the law would come down hard on you. But is that really a useful prescription for the law? Won't that drive feelings underground? Shouldn't we, instead of protecting black middle-class males from these indignities, and they are terrible, shouldn't we as a strategy be pushing the black middle class to come down harder on the underclass culture that sustains these legitimate presumptions? And isn't your prescription, calling for something that will never happen, likely to lead to a greater and greater radicalization of the black middle class and just make the problem worse?
Couple of points. First, on the question of utopianism. Legal norms, first, you're absolutely right that if by chance the Kennedy rule was adopted by the courts, and let's suppose that I become king for a day and I make a decree, and so the Kennedy rule becomes adopted. You're absolutely right when you say that it would be under-enforced. The police officer who now says that I focus on this suspect because of age, because of time of day, because of dress, and because of race, after the Kennedy rule comes down, some police officers will strike out race and mention the other three things, even though, in fact, race was one of the things that prompted his conduct. So you're right that there would be under-enforcement of my legal norm. That does not dissuade me from wanting to change the present state of the law, however, because the fact of the matter is legal norms are often under-enforced. But legal norms set the standards for legitimacy. If we change the legal norm, some people are going to act regardless of the change, but there are going to be some people who are going to want, even if they don't want to follow the law, there are going to be some people who are going to change their actions because they're going to want to conform to the law. The law sets the norms of legitimacy. The law is like a great magnet. It has its own sort of gravitational pull. It forces things, it pushes people to one tendency as opposed to another. Or to put it really dramatically, I would rather have the police officer have to engage in subterfuge. I would rather have the police officer engage in subterfuge as opposed to having the police officer have the law on his or her side, as is the case now. Now, on the question of the black middle class doing more, I'm totally opposed. Let me put it differently. Excuse me. I would would not want to tax particularly the black middle class. Black people who are middle class are American citizens. White people who are middle class, lower class, we're all Americans. The idea of a group having a particular responsibility, a particular burden, I'm against that. We are all Americans. This is a national problem. The problem of criminal youngsters is not a peculiar problem of black people. In fact, the problem of black youngsters is not the peculiar problem of black people. Those are our youngsters. Black, white, Asian American, whatever. And so I understand the objection, and I think it has a certain amount of force. With respect, by the way, to the cab driver example, I would distinguish in my own mind the cab driver from the police officer. After all, and the police officer, being an agent of the state with a bureaucracy, has a standing in our law and in our morals and in social life that's different from the cab driver. I'm glad that the cab driver has to face an anti-discrimination law, and I feel sympathy for the cab driver. I've talked to any number, I mean, again, in doing research for my book, I've talked to any number of cab drivers of all hues who engage in strategic racial discrimination. I've talked to plenty of African-American cab drivers who made no bones about it. Yes, I engage in strategic racial discrimination. They confront a dilemma. I sympathize with them. And in fact, one of my points in the book is, in our discussions, I think we've got to relax a bit. If there's a cab driver who was to stand up here right now and say, yeah, I engage in racial discrimination, my response to that cab driver wouldn't be, oh, you're a bigot, shut up, I want to lash you. I would say, okay, let's talk about it. And I would make a pitch to the cab driver and try to persuade the cab driver to my way of thinking. I might say, for instance, to the cab driver, is there a way in which perhaps we can spread the cost? You've got a problem. The problem is driving a cab is dangerous business, and you want to engage in self-protection. Is there some way in which we can make you feel more safe that does not involve you engaging in racial discrimination? Perhaps we could come to a good accommodation there. We cannot come to a good accommodation if the first thing that we think about and the last thing that we think about and the overwhelming thing that we think about is, again, reaching for the racial distinction. Sometimes we do have to reach for the racial distinction. I want that to be the very last thing.
Why don't we move forward?
Mr. Holmes?
Yeah, hi. Steve Holmes with the New York Times. I want to go back to the crack powdered cocaine discrepancy. And when we talk about racial discriminatory behavior, you have you have what's called disparate impact and disparate treatment. Now, regardless of whether or not the war on drugs is a war on black, the effect, the impact of the policy has been discriminatory, I think most people would argue. The question I have is, how do you attack this disparity? Do you say it's stupid to lock up crack dealers, it's wrong to lock up crack dealers more? Or do you say it's discriminatory to impose a penalty for the sale of crack that's greater than for the sale of an equal amount of powdered cocaine? Isn't it in fact discriminatory, and shouldn't that be the discussion? Because otherwise I don't see how you get anywhere by saying it's stupid or wrong. I don't think anybody would agree with that.
Oh, I think stupid government policy, I think, changes people's mind. On the question of discrimination, no, I don't think discrimination is a good way to go at it. Indeed, one of the themes of my book is that the idea of disparity has its place. It's an important notion, but in some instances, it has really been driven into the ground. Let's take crack. People often say the law is harmful to the black community. See how many black people are put in jail. Now, it seems to me that one's got to take that. I have two further considerations. First, in judging what's good or bad for the black community, one can't simply take a look at the color of the people being sent to jail. I want to talk to the neighbor of the person who's being sent to jail. The neighbor of the person who is black may be saying, "Great, I'm glad this guy is being sent to jail. This guy, this crack dealer, was trying to hook my kids on crack. So I'm glad that he's in jail, and the longer he's in jail, the better as far as I'm concerned." Often in these discussions, the center of attention is being put on the person being marched off to jail. Indeed, the person who is being marched off to jail becomes almost the class representative of the black community, as if it's only the person being sent off to jail whose interests matter. What about the black people left behind? We conflate the subclass of blacks, that is to say the subclass of black defendants, black convicts. They become the stand-ins for all black people. They are not the stand-ins for all black people. They happen to be black people who are engaged in forbidden activity. They are not the black community.
Didn't you earlier talk about one of the things that is needed is to moving towards a colorblind society, and also to diminish the cynicism that black people might have towards the system? If you have a policy which clearly has a discriminatory impact, how, unless you try and level that out, do you get rid of cynicism, and how do you move towards a colorblind society?
I think that's a good point you raise, and I would say two things. First, I think that people I think this point needs to be explained. I know there are a number of press people in the room, and I'm happy that they're here because I'd like to vent one of my frustrations. One of my frustrations has been that press people in the room get a press release from a side that talks about the disparities, and then write a news story as if this is racial discrimination and that's the end of the story. I think that the story is more complicated than that, and that one has to say in the description, this has an effect on a subcategory of the black community. On the other hand, there's this other aspect of the black community that has different feelings about it. That's number one. So there needs to be public education. I think that if there was enough attention paid to explaining to people what's going on, people might be less resentful. In various forums I've been in, people say, well, geez, isn't it unfair to criminalize the same thing differently? Because people have the idea that there really is no difference between crack and powder. And I say, hey, listen, there is a difference. Crack democratized cocaine. Crack made it so that a person with $5 could get a hold of cocaine, whereas before you had to be relatively wealthy to get cocaine. And a legislator should be able to take that into account and should be able to say the very fact that it's more accessible makes it a more dangerous poison, and therefore we're going to come down on it harder. Now let me get to the second point, though. It may be the case that a legislator might say there is a difference between these two drugs. It's reasonable to treat them differently. On the other hand, there's going to be a fairly large sector of the population, particularly the minority population, that is going to be made uncomfortable by this. They're going to think that there's some racial discrimination going on, and so there might be the appearance of unfairness. And so in deference to that appearance of unfairness, we're going to treat crack the same as powder. In fact, that I think is going to happen. There are a good number of people in Congress right now who were sort of hawks in the drug war, and what they're saying is, that's right, let's level up. Let's get rid of the disparity by putting the hammer down on people who deal in the powder cocaine. This happened, by the way, in Minnesota. The Minnesota Supreme Court, in, I think, an ill-considered opinion, struck down the crack powder distinction under state constitutional law. I think it was Russell versus the state of Minnesota. I don't think it was a well-taken opinion, but I think what happened afterwards is very interesting. The state Supreme Court said you cannot distinguish between crack and powder. They said it was racially discriminatory. I think they were wrong for reasons I've already articulated, but that's the way they ruled. The legislature then was put to a test. It had to even up the score one way or another. If the legislature had leveled down, my eyebrow would have gone up. I would have said, something seems amiss here. If they had leveled down, I would have said, well, if you thought a couple of years ago that crack was so pernicious, why are you leveling down now when it seems that you can either level up or level down? If it was so pernicious then, why are you lowering the penalties? The state legislature in Minnesota did not level down. They leveled up. They said, okay, the Supreme Court of Minnesota has told us that we have to deal with people, even Steven. So we're going to penalize powder dealers as harshly as we deal with crack dealers. That, it seemed to me, was an important development, an important datum, which suggested that at the outset that these were legislatures who were not engaged in any sort of racist campaign. They were people who were trying to do the best they could to deal with the problem of drugs. Now again, I want to emphasize, I think that the whole drug war ought to be reconsidered. I think that there are very responsible people who are raising very serious questions about the drug war. So all of this is not a brief for the drug war. All of this is a brief aimed at the problem of racial discrimination and what racial discrimination really is. And I think that to some extent, the definition of racial discrimination has been broadened into forms which really don't stand up under analysis. Mr. Denniston?
Lyle Denniston, Baltimore Sun. Randy, help me out a little bit. I haven't been able to read your book yet, but I'm skimming a little bit of it while sitting here at the table. You seem to draw a materially different conclusion about the way the Supreme Court dealt with the perception of racism in the administration of the death penalty when the victims were white, and the way you deal with the distinction in the disparities in sentencing for crack and powder. Are those two different phenomena? It strikes me that both of them, whether or not there was intentional discrimination, do contribute. The statistics contribute to the very perception that something racial is going on here. But do you see a distinction that I'm missing here?
I'm sorry, I don't really understand the question.
Your book, in discussing the McCleskey decision, is very critical of Justice Powell for not crediting David Baldus's study.
Yes.
And you suggest that indeed that the court may have reacted to that study, showing a direct correlation between the administration of the death penalty and the white race of the victim. And you are indeed, at least as I've perceived it, you're very critical of that. The Baldus study did contribute to the societal perception that race is a factor. Now, when you turn to the crack versus cocaine distinction, you say that that should not be contributing to the perception because there is a substantive problem with crack. But it seems to me that both do contribute to the perception that something racial is going on here.
Both do. There is a distinction to be drawn between the death penalty context and the context involving the crack powder distinction. Every federal court thus far has ruled against those who have challenged the constitutionality of the crack powder distinction on the grounds that there is no adequate showing of discriminatory purpose in this legislation. Now, and I agree with the federal courts on that. Now, turning to the death penalty, the Supreme Court ruled that there was no adequate showing of discriminatory purpose in the administration of capital punishment. I think that McCleskey versus Kemp is a very difficult, poses a very difficult issue. Frankly, my very harsh criticism of the Supreme Court did not go so much to the outcome, because I think the outcome, actually what to do, is very difficult, and I think people could differ. I'm not sure about what to do, frankly. My criticism had to do more with the rhetoric of the Supreme Court than anything else. I thought that the Supreme Court essentially whitewashed the problem of racial feeling, racial sentiment in our society. I thought that the statistics that were unearthed, which suggested that the people who enforce the law in Georgia get a lot more riled up when a white person is the victim of murder than a black person is the victim of murder. There was a lot of force there. Whatever one's conclusion as a legal matter, it seemed to me that there was a lot of force there. The Supreme Court should have indicated in the writing of the opinion that we have a real difficulty, especially given the history of the administration of capital punishment in the United States. I begin my chapter by talking about racial discrimination, capital punishment, and rape, and point out that in various jurisdictions for a long period of time, the only people ever sentenced to death for rape were black men accused of having raped white women. The courts had an appalling record with respect to that. Rape is no longer a punishment that is no longer a violation punishable by capital punishment. The Supreme Court never, and no court in the United States, adequately dealt with the racial discrimination, the clear racial discrimination in the rape context. The Supreme Court should have, whatever its conclusion, should have indicated to the public and should have indicated to the Congress that there's a real issue here, it's a difficult issue here that warrants our collective attention. That was really the fundamental point that I was trying to make in that chapter.
One last question.
My name is Jeff Weintraub. I'm with the American Jewish Committee. I'd like to hear your thoughts about the subject of jury nullification, which I imagine you've spent some time in your book discussing. There are some people right now who are claiming that this is getting to be a more severe and serious problem, especially in light of the success of Johnny Cochran in the O.J. Simpson trial, which many of you believe was an example of jury nullification. How serious of a problem, if you would call it a problem, is it right now? Where do you stand on that? What are the ways to respond to it?
I think it's an appreciable problem. I think it's probably rather marginal. I mean, I don't think it's prevalent, but I think it's appreciable. I think it's something that needs our attention. It's a problem that has become maybe more of a difficulty given that there are people who are, including a former student of mine, who was a law professor at George Washington University Law School, who is urging racially based jury nullification for nonviolent black criminal defendants. I spend about 15 pages in my book harshly criticizing that point of view. We have in our history some ugly examples, very ugly examples of racially based jury nullification. For much of our history, racially based jury nullification has been the preserve of white supremacists who appealed to white racial solidarity in getting juries to acquit people who were obviously guilty of the most heinous crimes. The Emmett Till case, which I talk about a good deal in my book, is an example of that. And that's terrible. Those were terrible things that are a stain on our history. More recently, of course, we have examples right here in this city. I've talked with people. I mean, I know people. I've talked with people who have told me to my face, and I believe them. They've told me to my face that they voted they voted against conviction of black defendants because they didn't want to send another black man to Lorton. I think that that attitude is profoundly counterproductive and needs to be stigmatized. As I stated earlier in my discussion, African Americans are more vulnerable to criminality than other sectors of the population. My person I was talking to was on a burglary case. My response to this person was, okay, so you let this fellow's gonna walk. This fellow's in a black neighborhood, so you're gonna let him walk. Whose house do you think he's gonna burglarize next? On its own grounds, this idea of black people appealing to notions of racial solidarity to nullify criminal prosecutions of black defendants, even on its own terms, is wrong. But there's a deeper way in which it's wrong. And the deeper way in which it's wrong is that we should be against any sort of racially motivated, racially mobilizing politics. We are all Americans. That is the central point. And there are, to get back to your point about jury nullification, there have been times in American history where radical evil required a radical redress. I mean, if the legal order is completely illegitimate, under those circumstances, the citizenry might have to engage in jury nullification. I mean, that's really akin to taking up arms against the government. It's akin to guerrilla warfare against the government. It is a profoundly subversive activity, and if circumstances warrant it, then fine. Circumstances do not warrant it in the United States, and therefore I think that that sort of talk is irresponsible, counterproductive, and has given vent to, in my view, very vicious sentiments. Thank you very much. Really appreciate it.
Thank you very much. I would just like to call attention, each of you received an invitation to our next book luncheon, which will be held next week on the 21st. We'll have Fred Lynch, who is the author of The Diversity Machine, The Drive to Change the White Male Workplace, and it will be held at our offices at 815 15th Street on the 10th floor conference room. And if any of you or all of you would like to attend, we welcome you there. Please just RSVP. Thanks again very much. Again, I would like a chance to welcome all of you. For those of you who do not know, am Linda Chavez. I'm president of the Center for Equal Opportunity, and the Center is a conservative organization that deals almost exclusively with the issues of race, ethnicity, language, and assimilation. At least we are described as conservative and by some of the people in this room. And I must say that if you had told me a couple of years ago when I started this organization that as the president of CEO, I would one day be hosting a luncheon to honor a liberal from Massachusetts named Kennedy, I would have told you you were crazy. But in fact, that is what we are here to do today. And it is in fact a great honor to be able to host Professor Randall Kennedy from Harvard University. Those of you in the room obviously know that Professor Kennedy is a professor at Harvard, and he earned his undergraduate degree at Princeton and his law degree at Yale. Professor Kennedy has taken on what is surely one of the most volatile public policy issues in America today, and that is the issue of race and crime. And to do so, and particularly to do so with the kind of integrity manifest in this book, requires an enormous amount of courage. The intertwining of race and crime is complicated. It's fraught with the baggage of our history as a nation. It is impossible to ignore that history when we talk about the subject of race and crime. And Professor Kennedy's book, in a very important way, challenges different people in different ways, and particularly different camps in the debate about race in America, namely the liberal camp and the conservative camp, in very different ways. He challenges liberals to confront the fact that, as he puts it...
Thank you very much for that kind introduction. I am very happy to be here and very grateful for this forum. I should say that this isn't the first time I've been at a forum at the Center. On two previous occasions, I came to the Center to be part of various discussions having to do with race and the administration of criminal justice. And indeed, those two earlier occasions were very helpful in the writing of my book. Here I'd like to give a special note of appreciation to Linda Chavez. The fact of the matter is that I am a liberal. I'm a person who sits on the editorial board of Dissent magazine, The Nation magazine, The American Prospect. And the American Prospect, I guess, is probably the most conservative of the editorial boards that I'm associated with. We obviously have certain agreements, but also certain disagreements. And I have always been dealt with in the most cordial way, the most respectful way, when we're agreeing and when we are disagreeing. And I'm very pleased to be here, and I have been very appreciative of the way that you have dealt with me over the years. My book, Race, Crime, and the Law, is a book that deals with the history of racial controversies in this area, race and the administration of criminal justice. About a third of the book deals with the history of this area. In focusing on the history, one of my aims was to...
The principal injury suffered by African Americans in relation to criminal matters is not over-enforcement of the laws, but under-enforcement. I think anyone living in Washington, D.C. can clearly recognize that the levels of criminality that those who must live in Northeast Washington or Southeast in what are primarily African American communities, those levels of criminality would never be tolerated in the white neighborhoods of this city and its suburbs, or indeed any major city in America. But he also challenges conservatives, particularly those of us who have spent our professional lifetimes arguing for colorblind policies We want colorblind admissions to universities, we want colorblind hiring, we want colorblind promotion. But are we prepared to deal with the kinds of colorblind law enforcement that Professor Kennedy writes about? Are we prepared to prevent the police from, as Professor Kennedy puts it, using race as a proxy for dangerousness? I've thought a lot about this issue, knowing that I was going to be sponsoring this luncheon for Professor Kennedy. And I must say, as I was thinking back on my own experiences and the one time in my life when I became an almost victim of a serious crime, I was forced to think about some of the issues that Professor Kennedy raised. Some 20 years ago, I was living in upper northwest Washington in a neighborhood called Shepherd Park, and I had just given birth to my second son, Pablo. And I was home with him and nursing him and put him down to bed in his bassinet in my living room and was headed to the kitchen for a cup of coffee when I realized as I walked through the living room that there was a man hidden in the corner underneath my stairway that went to the second floor. And in one of those moments which I look back on with utter amazement and think that it must have been providential, it must have been miraculous, I reacted in precisely the right way. I didn't flinch, I didn't in any way indicate that I saw this person, but instead continued walking into the kitchen, picked up the telephone and called 911 to alert the police that a man had broken into my house and that I was there alone with my infant son. I then turned around and went back to face the man who by this time had moved into the center of the room. He was a young man in his early 20s. He was black. He was very well dressed. And when I told him that I had just called the police, he reacted with utter contempt, suggesting that I had somehow made some terrible mistake and that he was simply there to inquire whether or not I needed my hedges trimmed, despite the fact that it was in the middle of the month of January and there was snow on the ground. He then acted quite insulted and turned around and walked out the door, and the minute his feet hit the pavement, began to run. Within 2 or 3 minutes, Washington's finest showed up at my door with their guns brandishing and pointed directly at me, and I informed them that in fact the young man had disappeared. I gave a very careful description. My husband's 6'2". This man was at least 2 inches taller. He was about 6'4". He was very distinctively dressed. He had on dark blue pants, bell bottoms, as it happened in the fashion of the time. He was wearing a camel hair coat, certainly not the kind of garb you would wear to trim hedges. And I estimated his age as late teens, early 20s. For the next hour or so, the police combed my neighborhood and brought prospective persons to my door for me to identify whether or not they were in fact the man who had broken into my house. After about the third black man had been brought to my house, I realized that the only thing that the police heard in my description, my very careful description, were the words black male. And in fact, because Shepherd Park, for those of you who know it, is a very well integrated neighborhood, in fact it's a majority black, it was then as well, most of the people that they were bringing to my door were in fact my neighbors. And in fact, the last man that was brought to my door was a man about 60 years of age, and he was wearing a work jacket and dungarees. And when I looked into his eyes and saw the anger and the humiliation that he felt as he looked at what he, I'm sure, perceived as this accusing white woman, I realized that even in this case, some of the police were black. That in the eyes of the police, the dangerousness, the part that they heard about my description, the fact that this man was an intruder into my home, the only thing that mattered was in fact his race. Well, I say that in introduction to Professor Kennedy's book because he has some very important things to say about such incidents as they happen throughout life. And I think he has some extremely intriguing notions about how colorblind law enforcement could ensure that those kinds of incidents never take place again. With that, I would like to introduce Professor Randall Kennedy, and he will speak for about 20-25 minutes, and then we will open it to question and answers. Thank you.